Nope, nothing starts here at 9:30 ever. That's okay. All right, sir. I'll obviously the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of true in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork? And the agreement was for 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now? So if they were agreed, I should have these printed out. We shouldn't have these. All right, and sorry, I know what.
Judge accepted the plea, then delivered the sentence. 2 years in prison, probation revoked, and no right to appeal.
And then just got it. Mr. Van Wright, in cause number 24 PCCR 2485, I'm going to find that you entered the plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered the plea of treaty count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the institutional division of the Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. Cases will run concurrently, which means together at the same time. I'm handing you, in each of those cases, trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws to make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with me. All right, good luck, sir. You can go back with me. Thank you, Miss Simmons. Come here. Okay. Okay. Hey, Mr. Lewis on Mark Garcia. Yes, ma'am. Thank you so much. Okay, if you call the name Mark Garcia, please. We're late. Mm-hmm. Mm-hmm. Driving in from. I know. All right, his bond will be forfeited for non-appearance and raised at 100,000. Clifford Norman, Mr. Lewis. Oh, I don't see. Clifford Norman. Just have a seat. I'll recall it in just a minute. What about Dragon Rose? Is there paperwork on him? I'll hold it. As soon as it comes through, I'll recall him. Mr. Kimler, you've got Ronald Soul. This is Miss Nothing No on Ronald Souls. Good morning, you're Ronald Souls. In cause number 25, DCCR 0252, Mr. Souls charged with unlawful possession of a firearm felon. Cases set for trial to begin with jury selection on Monday, January 5th. What is the announcement? Miss Nothing No. Alright, so I'm going to number the case. Obviously, everybody knows after today, no plea agreements unless something changes drastically with the information that you guys don't already have. Stay in touch with Mr. Kimler. You'll need to be back Monday the 5th at 1 o'clock. He'll know that for sure tomorrow, okay? Have you seen the video? I don't care where you're from. I mean, I don't mean that mean, but it really doesn't matter. You're still going to be required to be back here for your trial. So, but what I'd like to do is, do you have that? Do you have time to use, we can get a computer and y'all can sit in the jury room? Okay. Have a seat until we get all that. We're going to let you and Mr. Kimler watch the video that the state's attorney has. If that changes anything, we'll see this morning. If not, we'll never drop. Don't leave, okay? You've got Richard Robb. It's a sentencing, Mr. Kimler. Richard Robb is the sentencing. You should have a pre-sentence report. Oh, okay. Oh, yeah, it was the lesser. All right, sir, you're Richard Robb. And this is 24 DCCR 2170. Mr. Robb was previously here, entered a plea of guilty to the lesser offense of a Class A misdemeanor theft of property. And I reset it for sentencing. The agreement for 3 days in jail. And is there any reason not to go forward with sentencing? All right, sir, I'm going to find that you entered a plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor theft of property. Sentence you in accordance with that agreement to a term of 3 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been incarcerated on this case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bail. Got casual on that. Casual on that. Do you need me to take a break, or are you good? His bond will be forfeited for non-appearance and reset at 100,000. If he gets here this morning during docket, I'll call that. If we get him or he gets here, what is everyone's announcement? Who's set for trial? All right, it would be most likely the number 2 case, and so he has a warrant as well. Okay, we'll see. At least we'll know where he is when he gets arrested. Jason Harris, Mr. Kimler. Good morning. You're Jason Anthony Harris, and this is 24 DCCR 2254. Mr. Harris's case is set for trial to begin with jury selection on the 5th also, and what is the announcement? Have a seat in the jury box. Let's get you tested, and then we'll go from there on that. And Brianna Kleinen, sentencing. Kleinen, before we go forward with you, I'm also going to have you tested and have a seat in the jury box. Mr. Lewis on Clifford Norman. Good morning, sir. You're Clifford Norman. And Mr. Lewis, will your client waive the formal reading of the indictment? Mr. Norman, in cause number 25, DCCR 1034, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. And before you sign these, did you go over them with Mr. Lewis? Do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you would be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation, a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would include having no contact with a Kenneth Sweat. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization in I'm required to ask everyone. Do you understand that? Okay. State tenders number 1. It's admitted. Is there any evidence that Mr. Norman's not competent? All right, sir. I'm going to find that you entered your plea of guilty freely and voluntarily, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk. Yes, sir. All right, see you back at sentencing. And then Drayden Rose, Mr. Lewis. Good morning. Are you Drayden Rose? Excuse me. Lesser. Mr. Rose, will he waive the formal reading of the indictment? Mr. Rose, in cause number 25, DCCR 0789, the state has elected to proceed on the lesser included offense in Class A misdemeanor assault from April 16th, 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Ms. Lewis? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to? And it looks like the agreement is for a 1-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1. It's admitted. Is there any evidence Mr. Rose is not competent? And Mr. Smith, since it's been reduced, is there any history or any reason to get a pre-sentence report? So, Mr. Rose, I'm going to waive the pre-sentence report in your case. I'm going to find that you entered the plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm following the agreement that you made and deferring all proceedings and placing you on probation for 1 year in order to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have the conviction on you. And at the end of the probation period, if you are complete it satisfactorily, then the case will be dismissed. You'll never have that conviction. The other side of that is if you violate your probation, you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Once you get that, you'll just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so be watching for her to call you. All right, good luck to you, sir.
This defendant walked in hoping for closure. He walked out heading straight to prison, with sentences running together.
Hey, Mr. Burbank, you've got John Martin. He's Malfino on John Martin. Good morning, sir. You're John Martin. And this is 25 DCCR 0583. Mr. Martin is charged with injury to a child, elderly, or disabled individual. And what is the age? On what? Back in October. Okay. Okay, that would be great if you would see where they are in that process. We'll just do about 45 days reset, a little extra time, so hopefully we get those records back before then. You guys can review them and we'll see if we can get it out. Stay in touch with Mr. Burbank, and he'll let you know. All right? Yes, sir. Thank you.